Hello everyone, I am Vibha Chauhan and welcome to Chauhan Classes Funda Clear. So today I will explain chapter 6 from Indian Polity book written by M Laxmikanth, and the chapter is Citizenship. So in this chapter we will discuss from articles 5 to article 11, which come under the part 2 of the constitution. So as we had already discussed in the previous chapter from article 1 to article 4, which come under the part 1 of the constitution and deals with union and its territory, and in this chapter we will discuss about citizenship, and in next chapter we will be continuing this series, you can say series of articles. So in this chapter we will discuss about citizenship, that comes from under part 2 of the constitution from article 5 to 11. So in this chapter we will discuss about different conditions. What are the conditions on which Indian citizenship can be acquired or can be lost? We will discuss if an Indian person goes to abroad, then what happens to his citizenship. We will discuss in this chapter. So let us continue. Let us begin with our first topic, that is meaning and significance. Meaning and significance. So as you know, in any country, not in India, in any country there are two types, you can say, that are citizens. There are two types of persons, that are citizens and aliens. Citizens, that are country's population that have the citizenship of that country, and aliens, you can say any foreigner. And even in aliens there are two types, that are enemy aliens and friendly aliens. Friendly aliens are the subject of the cordial relation. In India, friendly aliens are those from the country that have cordial relation with India, and enemy aliens are those from the country which is at the war, which is as the war engaged with India, you can say. And citizens and aliens, so as you know that there are rights more for citizens, less for aliens, and even in aliens, friendly aliens enjoy more rights, you can say, than the enemy aliens. For example, they do not understand, they can't be protected against detention and arrest. You can say that this is a fundamental right under article 22 that is not provided for the, you can say, enemy aliens. And there are many fundamental rights that are for citizens of India and that are not for the aliens, you can say, not for friendly or for, you can say, enemy aliens. And those fundamental rights are from, you can say, article 20, article 18, article 16, article 15, you can say, that are for right to freedom, right of association, right of expression and thought, you can say, and that is of cultural and educational rights. There are many rights that are particularly for the citizens of India. So you can say that citizenship has its meaning and significance, and for citizens there are, you can say, they have rights to hold any post of India, that are of President of India, Prime Minister of India, judges of Supreme Court, High Courts, you can say that, and that are not meant for the aliens. And in India, a person can hold the post of, you can say, the House of President if he is a citizenship by birth and can even be a naturalized person that has acquired the citizenship of India by the method of naturalization. Whereas in USA, that is in America, only a person's citizenship of that has acquired citizenship by birth can acquire the post of president, not by naturalization. So our second topic is constitutional provisions. Constitutional provisions. So you know that citizenship that comes from article 5 to article 11 under part 2 of the constitution, and constitution hasn't engaged in this matter in citizenship. It has given power to the parliament, to the government of India to seek this matter, to seek the citizenship of India, to provide some new laws for citizenship, to terminate the citizenship. And the article 5 of the constitution says that a person who had his domicile in India can be a citizen of India, can get a citizenship of India if he fulfills three conditions, one of these three conditions. First is that he was born in India. Second, either of his parents were born in India, and third is that he has ordinary residence in India more than 5 years, or you can say for 5 years, then he will be a citizen of India, can get a citizenship of India. Article 6 of the Constitution says that any person from Pakistan who migrated to India, you can say after 19 July 1987 can get a citizenship if he is registered. If he is registered and has migrated after 19 July 1948, then he can get a citizenship of India. And if he has migrated before 19 July 1948, then it's nothing. He can get a citizenship without any registration. So you can say that Article 6 says that any person migrated from Pakistan to India can get a citizenship, and this is at the commencement of the Constitution. This is the commencement of the Constitution, you can say that. And Article 7 says that any person who migrated to Pakistan from India after 1 March 1987 and has returned to India, then he can get a citizenship of India. So you can say that in summary, you can say that any person who migrated to Pakistan and then returned can get a citizenship of India. And Article 8 of our Indian Constitution says that any person who was an Indian origin and had been living outside undivided India, then he can get a citizenship of India if he want to by taking, you can say, representative of diplomats of India, or you can say consulate of India. So you can say that Article 5 to Article 8 says about how anyone could get a citizenship of India at the day of its commencement of Constitution. And Article 9 of our Indian Constitution says that no citizen of India shall be continued to a citizen of India if he has volunteered any citizenship of any foreign country. If a person has taken citizenship of any foreign country, then his Indian citizenship, you can say, is seized. And Article 10 of our Indian Constitution says that every person who is deemed to be a citizenship of India must abide by law that are enacted by the Parliament of India, because if they have become a citizen of India, then it is not easy to get out of it. You can say that if you have become a citizen, then you have to abide by law. And Article 11, that is very important, it has given after the commencement of the Constitution, all the citizenship matters has been given, or the power of citizenship has been given to the Parliament. You know that Article 5 to Article 8 says that these have become citizens of India at the day of its commencement, that is 26 January 1950. But after that, all citizens will be made by the Parliament. All citizenship acts, you can say laws, will be made by the Parliament. So you can say that Indian Constitution doesn't deal with citizenship. It is the Parliament of India which deal with the citizenship of India. So our third topic is Citizenship Act 1955. Citizenship Act that was made for the citizenship of India and has been amended by, you can say, by many times. It has been amended through various ways, you can say that. And it says how we can acquire the citizenship of India and can lose the citizenship of India. So our first subtopic is acquisition of citizenship. Acquisition of citizenship. So you know that Citizenship Act of 1955 provides how anyone can acquire the citizenship of India, and it says that there are 5 ways to do it. Anyone can acquire the citizenship of India by the ways, you can say by 5 ways, that are by birth. So by birth, that is, if any person has born in India on or after 26 January 1950 and before 1 July 1987, then he is a citizenship of India. It doesn't matter what his parents' citizenship is or nationality is. If his parents are citizens of any other country, then it doesn't matter, because he is born in India after 26 January or on 26 January 1950 but before 1 July 1987. And in any case, if any person has born in India on or after 1 July 1987, then he can get a citizenship of India if both of his parents, if either of his parents or both of his parents were citizen at the time of his birth. And in any case, if any person has born after 3 December 2004, then he can get a citizenship of India. He is a citizen of India if either of his parents was citizen of India at the time of his birth, and another if either of his parents was citizen of India and another one was not an illegal migrant in India, you can say that. So you can say that by birth anyone can get citizenship by birth, that are the virtue of birth. So second is by descent. By descent, that is a virtue of descent, you can say that. So if any person has born in India on or after 26 January 1950 and his father was citizen of India at the time of his birth, then he is also a citizen of India. And if in any case any person has born after, you can say, 1 July 1987, then he is a citizen of India only if either of his parents was, you can say that, citizen of India at the time of his birth. You have to remember that in the first one, when he was born on or after 26 January 1950, then it is written as father. Father should be, you can say, citizen of India. But if he is born after, you can say, 1 July 1987, then he is a citizen of India if either of his parents was citizen of India at the time of his birth. And if he is born after 10 December 1992, then he can be citizen of India only by a registration, you can say that, after 1 year of his date of birth. So that minor child will be citizen of India. His father, you can say, his parents have to verify that he or she doesn't hold the passport of any foreign country, you can say that, because they have already, you can say, after 1 year of his date of birth, you can say that within 1 year of his date of birth, they have already registered for his citizenship, for his Indian citizenship. So he is, you can say, that citizen of India. And you can say that when he attains his full age, that is of his adult age 18, then he has to seize Indian citizenship if he doesn't renounce the citizenship of any foreign country, because till now he was citizen of both, you can say that. So he has to renounce his citizenship of foreign country, then he can get a citizenship of India, you can say, Indian citizenship. So third is by registration. By registration. So our central government, the parliament may, you can say, on paper, you can say on application, can give citizenship of India, can give Indian citizenship to any person if he possesses that he has been living in India for more than, you can say, 7 years, ordinarily 7 years, that is continuing 7 years. And second is that he has been married to an Indian citizen, then he would also become an Indian citizen. But before that, before application, they have to be living in India for more than, you can say, 7 years, for 7 years ordinarily, that is preceding the date of application. And third is that any person whose parents are citizen of India, then he is also a citizen of India. He can get citizenship of India by registration. a child, you can say a person of full age or capacity, can be citizen of India if his parents were citizen of independent India, and he has to form an application, and preceding the application date he has to live in India. He should be living in India for more than, you can say, for 12 months ordinary continuing, that is not non-stop, you can say that. And fourth, you can say, is that a person who is an Indian card holder for more than 5 years, he can acquire citizenship of India by registration within 12. For preceding the date of application, he should be living in India for 12 months, you can say, ordinarily. So next is by naturalization. So the parliament, the central government can give, we can say, citizenship by naturalization to the person if he or she possesses these things, that are: first, he is from a country that doesn't prevent Indians to be citizen of that country by naturalization. So suppose if there is a country and from that country a citizen want to be an Indian citizen by naturalization, but if he is from that country who doesn't support Indian citizens to be citizen of that country by, you can say, naturalization, then he would also not get citizenship in India by naturalization, you can say that. And second is that if he has renounced his, you can say, citizenship of that country, then Indian, you can say, government can give him naturalization citizenship by naturalization, the citizenship of India. And third is that he has been resided in India for more than, you can say, 12 months, you can say that. And fourth is that he is of a good character. If he is of a good character, then he can also get a citizenship of India by naturalization. And fifth is that he should have knowledge. If he has knowledge of any particular language of India, that is an 8th schedule of our Indian constitution, then he can get citizenship of India by naturalization. And while taking naturalization citizenship, he should have intention to reside in India and abide by law, you can say that. And by all this, you can say, by taking citizenship of India, he has to take an oath for allegiance to India. For allegiance for citizenship of India, to become a citizen of India, he should take an oath, you can say that. And these conditions can be waived by the Parliament of India, you can say that. It is not that Parliament always support this, it can waive these conditions for any person, for any particular person, you can say that, because Article 1 says that the power shall be given to the Parliament for citizenship. Then Parliament can do anything, you can say that. So next is by incorporation of territory. By incorporation of territory, that is, if India has acquired or conferred any foreign territory, then subjects, you can say, subjects of that country would also become citizens of India. And for this, the Parliament of India, you can say that, enact new acts, you can say that. For example, when Pondicherry was acquired, Parliament had enacted, that is Pondicherry Act of 1962, that is the Citizenship Pondicherry Act 1962. Under the Citizenship Act of 1955, you can say that. So you can say that it's also minor amendment in this. So you can say that by means of incorporation of territory, anyone can also get citizenship of India. So next is special provisions as to citizenship of persons covered by the Assam Accord. So special provisions for the person covered by the Assam Accord. So the Parliament had enacted Citizenship Amendment Act 1985 to resolve the issue, that was Assam Accord. That was the foreigners citizenship issue. So it made provisions that were, first was that if any person had come to Assam before 1 January 1966, then he would become citizen of Assam. That were simple procedures. And second was that if any person had come after, you can say 1974, you can say that if he had come after 1974 from Bangladesh, it was from the citizens from Bangladesh, then, and he has been detected for a foreigner, you can say he has been suspected foreigner, then he would be a, you can say 10 years citizen of India. There would be a time period of his citizenship expiry, that would be a 10 years period, and between those 10 years he would be considered as a citizen of India. He would have all fundamental rights that has been given to the citizens of India, except the right to vote, because there are specific rights for citizens of India. So you can say that Assam Accord that made two provisions mainly. So our next subtopic is loss of citizenship. Loss of citizenship. So the Citizenship Act 1955 also has provisions that says how anyone can lost his citizenship, Indian citizenship, and there are three ways by which any person can lose his Indian citizenship, and that are, first is by renunciation. By renunciation, that is any person is renunciating, that is if any Indian citizen is declaring that renouncing his Indian citizenship, that is he is renunciating his Indian citizenship by himself, by declaring. So his Indian citizenship would be seized by the government of India, you can say that. And second is by termination. By termination, that is if any Indian citizen has taken a citizenship of any foreign country, then his Indian citizenship would automatically be seized by the government of India, because the Constitution of India says for single citizenship, not for dual citizenships. So for this, you can say that if any person has taken citizenship of another country, of any foreign country, then his Indian citizenship would be terminated. And third is by deprivation. Deprivation, that is the Parliament of India can seize anyone's Indian citizenship if he has taken Indian citizenship by fraud, or because if he has given wrong details about him, then his Indian citizenship would be seized, would be deprivated. He would be deprivated of his Indian citizenship. And second is that if he has communicated or traded unlawfully with an enemy country, that is an enemy of India, then his Indian citizenship would be seized. And if he has been living to a foreign country for more than 7 years ordinarily, that is continuously, then his Indian citizenship would also be seized. And if he has shown disloyalty to the government, you can say to the Parliament of India, to the Constitution of India, then also his Indian citizenship would be seized. And you know that if his citizenship has been taken, then his children's citizenship, Indian citizenship would also be seized. But later when that minor child grows up, then he may take his Indian citizenship as well. So our next topic is single citizenship. So single citizenship, that is, that in India there is dual polity, that is of center and state, and in US as well there is dual polity, that is of federal and state. And in US there is a concept of dual citizenship as well, that is if a person in US has been citizenship, then he owns allegiance to both, to his state and as well as to the federal structure. You can say that a person in US is a citizen of that state as well as the central government, you can say that. Whereas in India there is a concept of single citizenship, because you can say that it's more enjoyable to the citizens of India, because in dual citizenship like in US there is also cases, there is always cases of discrimination. The state government seeks for discrimination, you can say, in the matter of, can seek for discrimination in the matter of employment, you can say that, to hold, you can say, public posts, you can say that. Whereas in single citizenship like of India, there is, you can say that a person is a citizen and owns allegiance only to the central government, not to the state government, you can say that, because India is a federal in structure but unitary, you can say that, in spirit. So there is a single citizenship in India like that is in Switzerland. So you can say that India's single citizenship matches in almost to the Switzerland's, but there are few differences in few cases. So Indian, you can say, there is single citizenship in India, but as we know, till 2019 the erstwhile of Jammu and Kashmir enjoyed its separate provisions, separate constitution, you can say that was made under the article 370 and 35A, but these were repealed, you can say that, because this was enacted by the constitution order of 1954 that was applicated to Jammu and Kashmir, and those were repealed by the Honorable Indian Prime Minister Sri Narendra Modi by enacting the Constitution Order of 2019, and these articles 370 and 35A were repealed. But in constitution textbooks, you can say, in constitution the text, these are written as well, you can say that, they have not been erased, you can say that. So you can say that before, earlier, you can say that India had two citizenship, but now it has its single citizenship, that is of central citizenship, central government citizenship. So our next topic is overseas citizenship of India. Overseas citizenship of India. So in September 2000, a committee was appointed by the government of India and it was chaired by L.M. Singhvi. So its surveying was to survey the diaspora of the Indian, global Indian, and it submitted its report in 2002 and demanded for an amendment in Citizenship Act of 1955 to grant citizenship to PIOs, that are person of Indian origins, you can say that. So PIO. So they demanded to grant citizenship to, you can say, cards to those PIOs, Indian cards to those PIOs, and for this in 2003 a scheme was, you can say, a scheme was enacted, that was OCI, and that was OCI, that was Overseas Citizenship of India, Overseas Citizenship of India. So it granted citizenship, you can say that, in this it was that it could grant citizenship for 16 countries PIOs except Pakistan and Bangladesh. And again in 2005 an amendment was done in Citizenship Act 1955, and by this it was that all, you can say, citizenship was granted, you can say, to all, you can say, citizens of PIOs, you can say, of countries except Pakistan and Bangladesh. So you can say that PIOs, an amendment was done in 2003 in Citizenship Act 1955, and after that they were granted, you can say, citizenship, Indian citizenship for 16 countries, and after that for all countries, and it was made as Overseas Citizen of India card holder, you can say that. In 2015 it was made Overseas Citizen of India card holder because a PIO scheme was introduced in 2003, and after that in 2005 OCI scheme card was introduced, and that made confusions in persons, you can say, in citizens, because there some way they were different and some way they were similar. So for this there were many confusions, and for this finally in 2015 an amendment was done in Citizenship Act 1955, and after that by merging PIO scheme and OCI scheme it was made as Overseas Citizen of India card holder, and it made, you can say, provisions in the Principal Act that were Registration of overseas citizen of India card holder. Registration of overseas citizen of India card holder. So who were registered as the overseas citizen of India card holder? Person who was, you can say, who was citizen, whose parents or grandparents were citizen at the time of commencement or after the time of, you can say, commencement of Indian Constitution, you can say that, or anyone who is of full age and wants, you can say, wants to be Indian, you can say, citizen, you can say that, or anyone who has been married to an overseas India card holder, overseas citizen of India card holder, or any person who is a child of, you can say that, an overseas citizen of India card holder, you can say that. So you can say that these persons are registered as an overseas citizen of India card holder. And that doesn't include person of Pakistan and Bangladesh. It is strictly written in our constitution, you can say that no person from Bangladesh and Pakistan would be considered as an overseas citizen of India card holder. Second is conferment of rights on overseas citizen of India card holder. Conferments of rights on overseas citizen of India card holder. So there are many rights that are conferred, you can say, that are not, you can say, provided to the overseas citizen of India card holder. That are, he should not be posted for the post, you can say, he should not be posted for the post of president or vice president or judge of Supreme Courts or High Courts, you can say that. He would not be, you can say, given rights to elect in, you can say, member of councils, you can say, or house of states, that are Rajya Sabha and Lok Sabha. And he should not be provided to right to elect, you can say, right to vote, you can say that. And he will not stand up in, you can say, elections, you can say, elections for Rajya Sabha or Lok Sabha, you can say that. And there are many rights that are conferred to those OCI holders, you can say, that are overseas citizen of India card holders, like in matters of employment and opportunities, that are right to employment and opportunities, right to freedom, right to religion. So these are rights that are conferred, that are not provided to overseas citizen of India card holder. And third is renunciation of overseas of India card holder. Renunciation of overseas citizen of India card holder. So if any, you can say, if any overseas citizen of India card holder, suppose if he renounces Indian citizenship, India card holder, then he would no longer be, you can say that, overseas citizen of India card holder. And after that, his spouse, that are who is he married, or his sons, you can say, or his children, would also be seized to Indian citizenship, you can say that. But if they want, after that minor child grows up, then he can acquire citizenship of India if he wants. So fourth and last is cancellation of registration as overseas citizen of India card holder. Cancellation of registration, how would we do it? So Parliament of India, Government of India can cancel off registration of overseas citizen of India card holder if he has done some fraud in acquiring the citizenship of India, that is overseas citizen of India card holder, and or if he has been in prison for more than, you can say, 2 years, or the Parliament of India can also, you can say, seize his Indian citizenship, cancel his Indian citizenship if he has shown some dissatisfaction to the Constitution of India. If he has shown disloyalty, you can say that, dissatisfaction to the Constitution of India, if he is not showing his gratitude, you can say, respect to the Constitution of India, then his Indian citizenship would also be seized. Or during a time during the time of war in which India is engaged, and if he is trading, or you can say communicating with the enemy country, you can say unlawfully, then also his Indian citizenship would be seized. And after know you that his children's citizenship would also be seized. So you can say that by all these ways his citizenship would be seized. So this is all about the chapter. So we have discussed about the citizenship from Article 5 to Article 11. So we have discussed which come under the Part 2 of the Constitution, and we have discussed how anyone can acquire citizenship, can lose citizenship of India, and what is overseas citizenship of India card holder. So you can say that we have covered from Article 5 to 11 completely in depth. So this is all about the chapter. I have discussed all topics and subtopics, and in next chapter we will continue our article sequence. You can say that next articles will be discussed in next chapter. So thank you very much.